Who told you Claude was your attorney? Because a federal judge just made it very clear it isn't. And the conversations you thought were private became evidence in a criminal trial. Earlier this year, a man under federal investigation opened an AI chatbot and used it to think through his legal situation. He asked questions. He explored possible arguments. He tried to understand what prosecutors might already know. Months later, those conversations appeared in court. A federal judge ruled they weren't protected by attorney-client privilege. That case raises a much bigger question. When you tell an AI something deeply personal, how private is that conversation really? In February 2026, Judge Jed Rakoff of the U.S. District Court for the Southern District of New York ruled that documents a criminal defendant created using the consumer version of Claude were not protected by attorney-client privilege or the work product doctrine. The court's reasoning focused on 3 points. Claude is not an attorney, the communications were not considered confidential in the legal sense, and the defendant had used the chatbot independently rather than under the direction of counsel. The defendant, Bradley Heppner, was later convicted, and the AI-generated documents became part of the evidence considered in the case. A separate copyright lawsuit reached a different legal issue but highlighted another aspect of AI conversations. In litigation involving OpenAI, a federal court ordered the production of a large sample of de-identified ChatGPT conversation logs under a protective order as part of the discovery process. The court concluded that, under the circumstances of that case, those records were discoverable. Company policies also provide important context. Anthropic's consumer privacy policy states that the company may disclose personal data when it has a good faith belief that disclosure is reasonably necessary. For example, to comply with applicable law or legal process, prevent serious harm, address fraud or illegal activity, or protect rights, property, or safety. The same policy also distinguishes consumer accounts from enterprise and team offerings, which operate under different contractual terms. Taken together, these cases and policies point to the same broader reality. Conversations with consumer AI services are not automatically treated as legally confidential simply because they feel personal. The way these systems handle conversations isn't an accident. It's part of how modern AI services operate. Server-side processing helps companies improve models, investigate abuse, respond to safety incidents, and comply with legal obligations. Those goals are legitimate, but they also create a trade-off. The same infrastructure that allows companies to improve and secure their products also means conversations may be retained, reviewed under certain circumstances, or produced when the law requires it. That's an important distinction. Privacy is not the same thing as legal confidentiality. A service can protect your information from public disclosure while still reserving the ability to access or disclose it under conditions described in its policies or required by law. Those two ideas often get blurred together. They're not the same. Here's what stands out to me. None of this was hidden. The court opinions are public. The privacy policies are public. The terms describing how consumer data may be handled are publicly available for anyone willing to read them. That's what makes this story interesting. It's not about secret surveillance. It's about the gap between what many people assume the word private means and what the published terms actually describe. It's also worth applying the same scrutiny consistently. Claude is one of the AI systems used in producing this channel. That doesn't exempt it from criticism. If anything, it makes transparency more important. The question isn't whether one company is uniquely good or uniquely bad. The question is whether users understand the relationship they're entering when they treat an AI chatbot like a trusted confidant. Watch how courts continue to treat AI conversations. Will future decisions draw clearer distinctions between consumer accounts, enterprise platforms, and attorney-supervised AI tools? Watch whether companies redesign their products to offer stronger confidentiality guarantees. And watch whether regulators push for simpler disclosures, plain language explanations of how conversations may be stored, used, or disclosed. Because as AI becomes more personal, the legal expectations surrounding those conversations will matter just as much as the technology itself. If you found this analysis useful, subscribe to The Skeptical Machine. Every week, we separate headlines from incentives and examine what the AI industry's biggest decisions actually reveal. Because privacy policies tell you what a company says it may do. Understanding what that means in practice is up to all of us.